4, a full bench of the Supreme Court observed that, and I quote, "a distinguishing feature of our Constitution, like that of some of the new Commonwealth countries, is the splitting of executive functions between what one might call political executive, which remains answerable to Parliament, and an independent, non-political executive in specific matters, consisting of, amongst others, the Director of Public Prosecution, the Service Commissions, and the Electoral Supervisory Commission, which are not answerable to Parliament. The purpose of this device," the learned judges continued, "institutionally was to insulate certain areas in the conduct of public affairs from political responsibility and control, thus ensuring the autonomy and their autonomy and independence," end of quote. Similarly, our Law Reform Commission in a 2009 report described the importance of safeguarding, and I quote again, "the stream of criminal justice being polluted by the inflow of noxious political contamination by segregating the process of prosecution entirely from general political consideration." And for years, statutes have respected this principle, including when the Independent Commission Against Corruption was set up, allowing the DPP to remain truly the apex prosecuting body of our country. That is, until the infamous, ill-reputed Financial Crimes Commission Act of 2023. Madam Speaker, the explanatory memorandum of this FCC bill in 2023 explicitly declared that the Financial Crimes Commission was to be the apex agency in Mauritius to detect, investigate, and prosecute financial crimes and any other ancillary offence connected thereto. That Act therefore provided at its section 4.3 that subject to this Act, the Commission shall, in the discharge of its functions and exercise of its powers, not be under the direction and control of any person or authority. A similar provision is made at section 11.3 for the role of the Director General of the Commission. Here already we'll see how a law passed by a simple majority aims to displace the DPP's constitutional prerogative under section 72 of the Constitution. This purported apex prosecuting authority is to be, as per section 7.3 and sections 10.1 of the Act, composed of commissioners, a Director General, and this is where the important bit comes in, appointed by the President, acting in accordance with the advice of Prime Minister, after the latter had consulted with the Leader of the Opposition. The terms and conditions of these appointments are to be determined by the Prime Minister alone. The possibility of political influence and considerations which endure during the tenure of the appointees is thus clear. The more so as the Constitution allows at section 113 subsection 4 for anyone appointed in such way to be required to vacate their office at any time after a general election held after that appointment. Madam Speaker, of course, a responsible and honest government would appoint to the FCC persons of integrity and moral independence. Of course, such a government would not try to interfere in the work of the Commission through secret back channels. And of course, appointees do not necessarily neglect their duties under the law to please those who put them in place. But, and this is the big but, Madam Speaker, one does not build a ship for fair weather. It is the storm that must be provided for. The same goes for our institutions and our laws. Their good functioning cannot depend only on the hope that morality and duty will prevail. There must be checks and balances to prevent any temptation to slide into the arbitrary. There must be safeguards for the day when the unscrupulous try to abuse the system, which is why, as we maintain the mode of appointment of the SEC for the time being, and I stress for the time being only, it is critical that the DPP, whose appointment is quasi-judicial, exercise scrutiny over the prosecuting function of the FCC. Unfortunately, Madam Speaker, this is not what the FCC Act of 2023 catered for. As the law stands today, after its investigations, The FCC has the power to institute criminal proceedings. Section 1421 of the Act does pay lip service to the constitutional role of the DPP by stating that the FCC's ability to initiate prosecution is without prejudice to the DPP's power under Section 72 of the Constitution. As such, it is said the DPP can discontinue prosecution in any criminal case which the FCC has lodged. That is what was advocated by and advanced by the bill's supporters in 2023. But Madam Speaker, the fact of the matter, do excuse me, I must confess I've just been appearing before the Supreme Court, so I slipped. I'm very sorry, Madam Speaker. But when the DPP is not put in presence of the file which led to the prosecution, how could the DPP in fact exercise his powers under Section 72 and step in to actually stop the prosecution? It would obviously be not possible. You see, Madam Speaker, the Prevention of Corruption Act of 2002 compelled the ICAC to submit a report to the DPP after the conclusion of an investigation. Such a report had to contain all material information, statements and documents uncovered during the inquiry, as well as a description of any evidence which was still in the ICAC's custody, and it had to be accompanied by the ICAC's recommendations. This allowed for the DPP to be properly informed of the outcome of the investigation and to be able to assess whether criminal proceedings were warranted or not. And he had the final say on the matter. In stark contrast, Madam Speaker, there is no such provision in the FCC Act. There is no report to be sent to the DPP. He therefore cannot be in a position to appreciate whether a prosecution initiated by the FCC is justified or not. In the absence of any information on a case, how can the DPP exercise his ability to discontinue proceedings or to step in to continue them, as the Constitution gives him the power to do? His role under Section 72 of our Supreme Law is thus severely curtailed, to say the least. Now, the aberrations, Madam Speaker, do not stop here. As at today, if the FCC decides that it will not prosecute because there is no report to the DPP, the latter may never know whether proceedings ought in fact to have been initiated. In fact, none of us would know. He may not even know that an investigation has been stopped. No one would know, not even us, because there is no obligation on the FCC to inform him. Again, the exercise of his powers under the Constitution was thus neutralized. The FCC Act does not stop there, and it goes a step further in its blatant disregard for the Constitution. Its Section 150, Madam Speaker, allows the Commission to compound any offence under the Act or under the Declaration of Assets Act. That is, if an investigation has uncovered an offence, the Commission has the discretion to grant to the offender the possibility of paying a fine or an amount not exceeding the maximum penalty. When this happens, there can be no criminal proceedings thereafter with respect to that offence. In other words, the FCC has the authority to offer to someone, against the payment of a fine, protection from prosecution, conviction before our courts, and jail sentences. And it can do so whenever it wishes to. It has no obligation to communicate on such a decision. That is so wrong. It is true that compounding does exist under a number of our statutes, mainly for offences related to banking, fiscal and financial offences. But in all of these cases, there is an obligation on the compounding authority, MRA or the like, to first obtain the DPP's prior authorization. The latter can decide that compounding will not do, and criminal proceedings should be initiated instead. The DPP has no such power when it comes to compounding under the FCC Act. What is more, he is deprived of his ability to initiate proceedings of his own against the offender, as Section 150 of the Act prevents any case from being brought against a person who has benefited from compounding by the FCC. Once again, the Director of Public Prosecutions is robbed, and there is no other word, is robbed of his prerogatives under Section 72 of the Constitution. Madam Speaker, this is the situation which this bill addresses. The different clauses of our bill aim to restore the DPP as the apex prosecution authority in our land, including for cases that fall within the FCC Act. Accordingly, Clause 5 of the bill provides amendments to the Financial Crimes Commission Act 2023 so that no prosecution for an offence under that Act or the Declaration of Assets Act shall be instituted except by or with the consent of the Director of Public Prosecutions. The Financial Crimes Commission will therefore have no discretion in instituting or discontinuing criminal proceedings under those enactments. In addition, further related amendments are being brought to the Financial Crimes Commission Act to provide that where the Financial Crimes Commission determines that an investigation should be discontinued, it shall, and there is an obligation there, it shall send a report to the DPP setting out its reasons. Where the director, in another case, if the director does not advise prosecution or any action, he may also require the Financial Crimes Commission to conduct such further inquiries as he considers fit to advise. And thirdly, any offence to be compounded under either the FCC Act or the Declaration of Assets Act must henceforth be with his consent and approval. Madam Speaker, there is also a series of consequential amendments to other statutes in order to erase the act of legislative vandalism that has been made against our constitutional order. Clause 2 of the bill provides for amendments to be brought to the courts with a view to empowering the Director of Public Prosecutions to be the sole authority to determine whether an information relating to a financial crime shall be laid before the Financial Crimes Division of the Intermediate Court or the Financial Crimes Division of the Supreme Court. Clause 3 of the bill, Madam Speaker, provides amendments to be brought to the Criminal Appeal Act to restore the right only to the DPP to make an appeal to the Court of Criminal Appeal against the final decision of the Supreme Court with regard to any offence under the Financial Crimes Commission Act and the Declaration of Assets Act. The Financial Crimes Commission was given a similar right of appeal to the Supreme Court under the District and Intermediate Court's Criminal Jurisdiction Act against the final decision of the District Court or the Intermediate Court with regards to any offence under the FCC Act or the Declaration of Assets Act. Clause 4 of the bill, Madam Speaker, therefore provides for amendments to be brought to the District and Intermediate Court's Criminal Jurisdiction Act to restore that right of appeal only to the DPP. Madam Speaker, the FCC Act 2023, a law passed by a simple majority, cannot trump, no pun intended, the provisions of our Constitution. It cannot be allowed to curtail the prerogatives of the DPP under Section 72 of our Supreme Law, and it most certainly cannot contravene the principles of democracy enshrined in Section 1. The passage of this bill today is not simply a legislative correction. It is a moral obligation. It is a declaration that our institutions are not bargaining chips in political games, that our Constitution is not a plaything to be controlled at will. It is a message to our citizens that they can once again believe in the fairness of our law and the impartiality of our justice system. Madam Speaker, through this bill, we do not merely amend a law. We seek to restore justice, reaffirm democracy, and recommit ourselves to the ideals that make the Republic of Mauritius a sovereign and democratic state. With these words, Madam Speaker, I commend the bill to the House.
You're seconding the bill. Dr. Boulel is seconding the bill. Okay. So now I will call on the Honourable Leader of the Opposition.
Merci, Madame la Présidente. Merci de me donner l'occasion d'intervenir cet après-midi sur ce projet de loi, c'est-à-dire le Financial Crimes Commission Miscellaneous Provisions Bill. Madame la Présidente, c'est un projet de loi selon l'explanatory memorandum qui propose des amendements afin de donner le pouvoir au directeur des poursuites publiques d'entamer des poursuites ou de ne pas donner suite à des enquêtes effectuées par la Financial Crimes Commission. Madame la Présidente, l'ancien gouvernement avait, avec raison, mis en place la Financial Crimes Commission afin de créer une autorité de régulation indépendante pour la mise en œuvre des mesures strictes de lutte contre, premièrement, le blanchiment d'argent et le financement du terrorisme. Et cette commission, Madame la Présidente, avait permis à l'île Maurice de faire face à ces défis spécifiques dont on était confronté en tant que centre financier international. Et la mise en place de cette commission souligne l'importance de la coopération et de la collaboration internationale dans la lutte contre les crimes financiers transnationaux. À l'époque de la création de la FCC s'inscrivait également dans le droit fil des engagements que nous avions pris avec le groupe d'action financière GAFI, selon lesquels Maurice va continuer à se doter d'institutions fortes pour mener une lutte sans relâche, Madame la Présidente, contre toute forme de transaction illicite qui transitait par notre centre financier. Alors, l'objectif de l'ancien gouvernement, avec l'introduction de cette loi, était en finalité, Madame la Présidente, d'améliorer la réputation de notre île comme une juridiction propre et transparente. Et aujourd'hui, Madame la Présidente, le présent gouvernement propose des amendements pour redonner le pouvoir au directeur des poursuites publiques d'entamer les poursuites après les enquêtes de la Financial Crimes Commission. La question qu'on est en droit de se poser cet après-midi, Madame la Présidente, c'est est-ce que ces amendements apporteront des meilleures retombées dans les enquêtes contre les crimes financiers ou est-ce que cela ne va pas retarder les poursuites? Le temps nous le dira, Madame la Présidente. Je note d'abord, Madame la Présidente, que ces amendements visent uniquement à restaurer les droits de poursuite au directeur des poursuites publiques. Alors, je suis en droit, Madame la Présidente, de présumer donc que le gouvernement considère que le reste du Financial Crimes Commission Act est correct et représente une amélioration sur la précédente loi qui était la POCA et qui était introduite par le gouvernement MSM-MMM en 2002. Et, Madame la Présidente, je pense qu'il est de mon devoir de rappeler à cette Chambre brièvement certaines grandes avancées sous le Financial Crimes Commission Act, à commencer par l'introduction d'une nouvelle définition de property qui n'a jamais existé dans aucune loi avant. Et property a maintenant, Madame la Présidente, une définition plus large qui inclut any right or interest in the property. Donc, même si une personne n'est pas le propriétaire officiel of a property, un intérêt prouvé dans ce property qui est lié au crime suffirait, Madame la Présidente. Il y a aussi cette notion de compensation order. une personne contre qui un confiscation order ou un attachment order a été injustement émis peut désormais demander a compensation order en cours. Il y a aussi, Madame la Présidente, l'introduction de corruption in private entities et...
Yes, one moment.
My point of order is as follows. The Honourable Leader of the Opposition should stick to the subject matter of the debate. It should not be an opportunity for him to revisit the bill, the debate that took place in 2023. And this is precisely what he's doing, saying there was this, there was that, and there was something else. We're here to stick within the parameters of the bill, and this is what the Attorney General did.
That's what I said this morning.
Yes,
Or this
so let us be
afternoon.
relevant.
Please try and follow.
Yeah, I'm trying to do that, Madam Speaker, but I'm not being irrelevant. We are amending the Financial Crimes Commission Act. Although it is being referred to some specific, the Attorney General himself said that we will come with further legislation.
No, but then you will. Let me. Everybody's a speaker today. Then you will intervene when he comes. It's true that today, c'est très bref en fait, c'est très clair et très net. Donc venez directement sur l'amendement lui-même et non pas sur la loi telle que c'était et qui va peut-être être amendée plus tard. Essayez d'être plus direct, on va dire.
I shall try, Madam Speaker, and I'll be brief also. Let me get back to my speech, because I mentioned some of the specific clauses related to the Financial Crimes Commission Act, which today allows us to be more prudent in what we are doing. Madame la Présidente.
Excusez-moi, monsieur le responsable de l'opposition, le débat, si j'ai bien compris, en plus en tant qu'ancien Attorney General, je devrais dire, le débat est sur la fonction du DPP qui est restaurée. C'est là-dessus qu'il faut parler. Vous pouvez ne pas être d'accord, bien sûr, et non pas sur le projet de loi dans son ensemble.
Alors, permettez-moi, comme vous le dites, Madame la Présidente, d'aborder la pomme de discorde alors, de ces débats.
Voilà.
Et cela concerne les pouvoirs
Voilà.
du directeur des poursuites publiques. Alors, permettez-moi de prendre comme référence ce qu'avait dit l'ancien Premier ministre lors des débats sur le Financial Crimes Commission Act en 2023 concernant les pouvoirs
Voilà.
du directeur des poursuites publiques. And I quote, "It is to be noted that the constitutional powers of the DPP are not being affected at all. The DPP will retain his powers under Section 72(3)(b) and C of the Constitution and can therefore take over and continue or discontinue at any stage any such criminal proceeding instituted by the FCC. Where he decides to discontinue any such proceedings, he may give reasons as he may deem fit for such discontinuance. However, an aggrieved party may apply to the Supreme Court for a judicial review of his decision." Et je me réfère à ce que l'honorable qui avait pris un point of order tout à l'heure, l'honorable Shakil Mohamed, avait dit et réagi à cette partie du discours de l'ancien Premier ministre. And I quote, "I agree with the Honorable Prime Minister that the DPP retains the right to discontinue proceedings. I totally agree with Section 72(3)(b) and C. Et il cite je n'ai pas de problème avec ça. Je voudrais aussi, Madame la Présidente, revenir sur un extrait du discours, parce que moi aussi j'ai été intervenu ce jour-là, de notre intervenant lors des débats de 2023, et en particulier l'ancien Premier ministre adjoint, Ivan Kolan-Davidou, qui évoquait la Prosecution Commission Bill et avait dit ceci, je cite, « Le DPP n'est pas exempté d'erreur, il n'est pas above the law. » Naturellement, je ne remets pas en question l'intégrité de l'actuel directeur des poursuites publiques, loin de là, Madame la Présidente. Madame la Présidente, après avoir dit ce que j'ai dit, et en restant toujours dans le droit fil de ce projet de loi, je vais conclure, Madame la Présidente, avec un message suivant pour le gouvernement. Vous avez, certes, comme l'honorable Paul Béranger l'a dit tout à l'heure là, vous avez été élu avec une majorité absolue. Et c'est très bien. Mais un peu...
Let everybody have a good laugh.
Yeah.
It's good for the, you can also have a good laugh.
C'est très bien, mais c'est moins bien pour la démocratie. Mais ainsi est fait notre système, Madame la Présidente. Et ce peuple ne souhaite aucun abus de votre part. J'en ai terminé, Madame la Présidente.
Honorable Damri, I think, if I'm not mistaken. Yes.
Madam Speaker, with a copy of our sacred Constitution in my hand, I commend the Attorney General for introducing this bill of massive importance to the financial sector and to the nation. Back in 2023, the proposed enactment of the Financial Crimes Commission Act caused a public row that highlighted the scandalous attempt by the previous government to infringe on the powers of the Director of Public Prosecution. The transfer of powers of prosecution for financial crimes to the newly appointed Director of the Financial Crimes Commission, an officer appointed by the Prime Minister only, was a gross attempt to flout our sacred Constitution and undermine the very foundations of justice. Wielding powers of prosecution to an individual who is not independent is not only anti-constitutional, it is cruel. Loyalty and independence are inherently contradictory. Allow me to quote William Shakespeare in Macbeth. Who can be wise, amazed, temperate and furious, loyal and neutral in a moment? No men, unquote. No men, Madam Speaker, no men can claim to be independent under the circumstances set by the previous version of the Financial Crimes Commission Act. Yet, the previous government chose to push for this provision. They felt emboldened enough to go one step further in the systemic state capture of our institutions. It illustrates the utter disregard for our Constitution, for the democratic principle that we Mauritians cherish, utter contempt for the rule of law. This, Madam Speaker, was the hallmark of the previous government. At the end of 2023, it became very clear that Mauritius was slowly but surely drifting towards autocracy. Prime Minister Dr. Ramgoolam knew too well the risk of a biased Financial Crimes Commission applying arbitrary charges on Mauritians of all walks of life on the ground of diverging political opinion. He himself has been a victim of a political vendetta. You will recall, maybe not many of you know in this House, that Prime Minister Dr. Ram Ghulam joined politics for a cause, to fight for justice in the courts and in all spheres of life. He fought to maintain the Privy Council as the highest court for Mauritius, sparing the country from threat that an autocratic government would infringe on the judiciary and deprive Mauritians of a fair justice system. It is in his DNA to fight to restitute the full powers of the DPP. In the light of the past experience of the previous government, it became obvious that the only route to restore the systems of checks and balances in the financial system was to kick the previous government out of office and its MPs out of parliament. The people of Mauritius voted intelligently. This, Madam Speaker, is such a relief. I still wonder what drove the previous government to hijack the democratic system prevailing in this country.
Yes, one moment,
Yes.
please order. Yes,
Yes, I believe the Speaker is being very relevant.
yes, and also you reading from your paper. Try and come and talk on the bill, please.
Yes, I think I am speaking about the powers of the DPP at the moment.
Well, try and,
Yes. Okay, I'll be... So, perhaps it was the illusion of isolation. Being on an island, they assumed that catastrophic mismanagement would escape international scrutiny. While we were producing this glaring loophole in our financial legislation, Madam Speaker, the financial community was ringing alarm bells. Madam Speaker, in his address, the Honourable Leader of the Opposition stated that the 2023 Act was passed to strengthen our financial services sector. That's what the Honourable Member said. So let's analyse his statement for a moment. World over, governments are reinforcing their legislation to curb the flows of illegal finance and consolidate the trust in their financial system. The track for illicit funds and illegal financing cuts across borders and jurisdictions. When our Financial Crimes Commission Bill was voted, Mauritius had just been able to untangle the threads of the Financial Action Task Force, FATF, that were choking our global business sector. The last thing we needed was another blow to our reputation. A law that allowed some financial crime could go unprosecuted and therefore unpunished. Did it occur to the previous government that this legislation was about to weaken the fundamentals of an economic activity that accounts for 15% of our GDP? Did they even consider the impact of a poor legislation on the much-needed flow of foreign currency that keeps our balance of payment afloat? Was it an overconfidence bias or just sheer incompetence that led the previous government to believe that the integrity of our financial center would not be damaged from such obvious flaws in our laws? This is not mine to answer. I am just happy that we are now undoing the process and restoring trust and confidence in our jurisdiction for the benefit of all Mauritians. As we are turning the page on this sad chapter in our legislative history, it is time to look forward and think of what we would like to build for the future. In our program, we said we wanted to build a bridge to the future. Yes, we are restoring the powers of the DPP in the matters of financial crime. Our goal is to ensure that in the future there is manifest independence in the conduct of prosecution, of all prosecutions. Luckily, we are not the previous government. We are not a bunch of mindless, power-hungry politicians. Otherwise, we would have already used the provisions of the present Financial Crimes Commission Act to put charges on the previous government's leaders and their cronies. It would have been so easy to do it, but we chose not to. We didn't do it because we wanted to show that we are faithful to the spirit of the Constitution, faithful to the ideals of our founding fathers. We want the public to see that we mean business when we say that imported prosecution decisions will be exercised on strictly neutral grounds. Meanwhile, Madam Speaker, there are numerous suspicions of financial crimes from the previous government that the public would like to see brought to port. Understandably, the public is impatient, thirsty for accountability, but the public needs to know that any proceedings will be carried out with fairness and impartiality, as we pledged to do. We are building a system that is made to last, not a short-lived framework to mark a political transition. With this, I commend the Attorney General to bring the bill to the House. Thank you.
I will suspend the House for about half an hour. Half an hour. Let's say 4h30, 5 heures. 5 o'clock.